Good morning to all. I'm Kevin Johnson, I'm the Dean of the Law School, and I'm going to give a very brief introduction to a person who truly needs no introduction. Ralph Nader is an attorney, an author, and an activist. He was a candidate for the U.S. presidency in 1996, 2000, 2004, 2008. He championed consumer protection, environmental protection, and democratic government. He's a graduate of Princeton and Harvard Law School. And after a brief stint in the United States Army, he worked as a lawyer and history and government professor. Next, Mr. Nader went to Washington, worked with Assistant Secretary of Labor Daniel Patrick Moynihan, later for the United States Senate. His first consumer safety article was published by law students in the Harvard Law Record. In 1965, Ralph Nader published Unsafe at Any Speed, a study that revealed that many U.S. automobiles were unsafe. Hundreds of activists inspired by Ralph Nader's work came to Washington, D.C. to help him with other projects, including the infamous Raiders Naders, and we have a vintage t-shirt in the second row. The rest, as they say, is history. Please join me in welcoming Ralph Nader to UC Davis School of Law.
Thank you very much, Dean Johnson. Thank you all for coming on such short notice. I'm going to cover a lot of ground, and if you're so inclined, you might want to take down some of the references and websites, because if you're interested in a certain section of what I have to say, it stands to reason you're going to be interested in elaborating it with further references. Just for my own knowledge, how many people here are 1L? How many are 2L? How many are 3L? Exactly as I predicted. Study after study has shown that 1Ls come in very idealistic, and they get jaded, and as they move to 2L and 3L, they become very practical, and they think they know what they want to do, and therefore they don't have to expand their horizons. Because they become specialized pretty much, and they know what kind of law they prefer to practice. I hope the 1Ls here don't fall into that trap, because it's almost an inexorable move in that more and more narrow direction. And there have been a lot of articles and studies showing that over the years. They often explain it as a incremental and relentless accretion of cynicism that you start absorbing when you go into 2L and into 3L. Just for your own awareness, how many 1Ls again? And how many 2Ls? How many 3? Yeah. See what I mean? Okay, we'll excuse the upper class. I want to share with you some thoughts of what law school was like back in the late 50s when I was at the Harvard Law School, so that you'd have a frame of reference as to what has preceded. The curriculums are much better today, in no small part because of active students in the 60s and 70s, sprinkled through the 80s and 90s in this decade, demanding that the curriculum reflects something other than the commercial job market for law school graduates, and that it more and more embraces the unfulfilled demands for justice, which exceeds its supply. And so law schools today have courses on civil rights, poverty law, women's law, gay lesbian law, animal rights law, environmental law, consumer protection law, and even corporate crime, of course. And none of those operated in the curriculum of the exalted Harvard Law School in the 1950s. And was there corporate crime in the 1950s? Yeah. Were there consumer abuses? We had a course called Landlord-Tenant, and we never got to the tenant. Harvard Law School graduates, we're not going to spend our time representing tenants. The money was representing landlords. And now that doesn't mean that the curriculum is finished in terms of its evolution. You might want to ask yourself what other courses you might want to recommend to the faculty, or the faculty itself is recommended to the administration. Secondly, I want to ask you some questions about whether you've ever discussed here in your law school experience, and since so many are one out, it's not a fair question, but the distinction between a lawyer and an attorney. How about the 2L, 3L? Have you ever had a discussion in the classroom? Distinction between a lawyer and an attorney. Have you ever discussed what the phrase officer of the court means? No? Okay. Now, one problem with law schools, and it's not just here, it's all over the country, is they get the students so deep into the trees that they don't look to forests. And you're going to become quasi-official people when you pass the bar. Quasi-official. That's what officer of the court means. You're going to be given a monopoly of representation. And in that comes certain obligations. And there's been very little discussion about what obligations are entailed in the phrase officer of the court. In fact, one scholar wrote an article in the Kentucky Law Journal about 15 years ago exploring what that phrase officer of the court means, and he concluded about the only thing it means in terms of any judicial decisions or statutes is that lawyers have to obey the criminal law. This is a rather limited level of responsibility. So you might want to ask yourself, what other obligations are there? For example, can a judge order a lawyer to represent an indigenous client? Other than just being part of pro bono voluntary acceding to a judge's request. The difference between a lawyer and an attorney is an attorney attorneys for a client, usually through a retainer, and zealously represents the client, while a lawyer has a broader responsibility for the overall administration of justice. That is, beyond the client. There's another arc, another concentric circle, because an attorney should be a lawyer, and a lawyer, of course, should be an attorney. And this is often called law reform, administrative law reform, judicial reform, etc., that invite the obligations of the code of ethics for an attorney. Those codes of ethics are not just something you put up on your office wall for your client's astonishment. They are designed to define the unique responsibilities that attorneys have in return for their license to practice a monopolistic access to the courts on behalf of their clients. So when you decide what courses you're going to take, never determine the courses you're going to select here at Davis based on your bar exam challenges. Because if you do, you're going to exclude from your choices some of the most important courses taught, like jurisprudence. You can say, jurisprudence? That's not tested on the California bar exam. Who needs it? What you should do is pick the courses that are congenial with broadening your horizon and your sense of duty to those millions of Americans who are excluded from legal representation, or if they are accused of crimes, are given very subpar, incompetent legal representation, or vastly overburdened public defenders who sometimes have 800-900 cases per public defender in a very underpaid category of our profession, a situation we should be professionally ashamed of. And if one way to look at it is just rely on the cram course. The cram course is run by people who have one measure of their success, the percentage of those of you who get through the bar and who pass the bar. So they're very instrumental, they're very knowledgeable, they're very clever, and just rely on the cram course. Don't by any means distort your choices of courses based on the bar. If it consoles you at all, I have stated on many occasions that give me a good high school graduate, and in 15 months, I can get that high school graduate to pass the bar in any state in the country. That's how instrumental these cram courses can be. So relax, don't get anxious, and take the courses like equitable remedies and jurisprudence and some international law, which are not tested on these narrow bar examinations. The bar exam is crammable in more ways than one. Remember that, okay? Now, let's start with the substance of my remarks. Marcus Cicero, the great Roman orator and attorney, once defined freedom for the ages, in my judgment. He called freedom this way. He defined freedom as participation in power. Freedom is participation in power. Now, by that definition, we don't have much power in this country. Certainly nowhere near as what the pretenses of our alleged democracy would entail. And I think part of it is that people in this country confuse personal freedom with civic freedom. What Cicero was talking about was civic freedom, that is, participation in the processes of government, for example, the ability to have access to justice, per se, the ability to get your day in court when you're defrauded or you have a wrongful injury. Personal freedom is not civic freedom. I mean, we all have the freedom. I mean, dictatorships allow people a lot of personal freedom as long as they keep their nose out of politics. And we have more personal freedom than those in dictatorships. I mean, we can eat what we want, put the clothes on what we want, choose the hobbies we want, select the friends who we want, date who we want, marry who we want, divorce when we want. We can go whatever movies we want. We can download whatever music we want. We can pick whatever channel of television we want to watch with our clicker. We can get into a 5,000-pound vehicle and go down 3 blocks and buy chiclets if we want. But that's not civic freedom. And often that's confused. And it becomes a controlling process in and of itself. You know, what are you claiming about? This is a free country. Look what you can do. But it's important to make that distinction between personal freedom and civic freedom. Now, there are those who teach the Chicago School of Economics. I hope none of them are at this law school, because you didn't come here to be empirically starved, did you? And I want to give you a little story. How many of you have heard of Judge Posner? Right, well, you know, he's very prolific. He writes a book every 9 months, to my latest calculation. And he's very smart. He was 4 years behind me at Harvard, and he's very smart, and he writes more judicial opinions than any 3 Federal Court of Appeals judges. And he also teaches part-time a course at the University of Chicago. Well, some years ago, and this is an eyewitness account, he walked into the first day of his class, and he introduced himself, and the students were suitably awed. And he turned around, and on the blackboard, he wrote in big letters, "Justice." And then he turned around, he looked the students in the eye, he said, "You see that word? I don't want to ever hear that word again in my course." That's the monetization of justice. And that's the Chicago School of Economics. Everything can be monetized. And when everything can be monetized, everything is for sale. And are you prepared to accept the notion that everything is for sale? And not only that, but it excludes a whole range of empirical phenomena, reality otherwise, from this dogma, which someday will be looked at as any number of fancified ideological fads that have swept through the legal academic institutions over the last 150 years. But be very aware that when you get a Chicago School of Economics analysis of tort law or contract law, be very aware of what is deleted in terms of reality. Now, I want to ask you, how many of you, if you were paid $120,000 a year, would like to be public interest lawyers? Can I see the hand? How many of you at 100,000? 80,000? 60? 40? Okay. Okay. So it is this very serious question. because you're going to come out of law school probably with a lot of debts, right? You do have a loan forgiveness program, I understand. Harvard has a loan forgiveness program. It goes up to $50-some thousand, and it's undersubscribed. Although I don't know about this year, given law firms closing down and so on, whether that will be undersubscribed. But that's one of the burdens that you're going to come out of law school with that's going to make you risk averse in terms of what kind of career, what kind of law you want to practice, who you want to represent, how you're going to take your conscience to work every day. Now, I co-authored a book in 1996 called No Contest. It was on corporate lawyers and the perversion of justice in America. And it's in your library. I know because I sent it to every law school library. And I would urge you to look it up and just read the introduction to see, to get a sense of what you're getting into when you go to work for these corporate law firms. Because they really are not very likely to let you take your conscience to work. They'll let you take your technical expertise to work. It's a very, very hierarchical, very, very disciplined, one might say almost militarily disciplined institution, especially if it's a giant law firm. And there are all kinds of cues that, in effect, you learn to realize from that if you go off the expected upward track, that you're going to be penalized and you're not going to get partnership, and et cetera, et cetera. But one of the things you have to ask yourself, and this is a time to think about it, is what are you going to refuse by way of an assignment in these law firms? Where are you going to draw the line? I mean, let's say they wanted you to represent a coal mine company that imposed the broad form deed in the 1920s and 1930s on the horrifically poor people of Appalachia. And the broad form deed, basically, which they got these poor people to sign, gave the entire property rights for all underground minerals under the land that these poor people owned in those Appalachian hollows to the coal company, and that there was no liability for any damage if those minerals were extracted underneath the land of these poor people. Whether it's toxics, whether it's subsidence, whatever. Absolutely no liability. And then in return for doing this, the people were paid an annual fee of 25 cents an acre. Would you work on that assignment? Knowing that these poor people were semi-starved in the Depression and didn't have any bargaining power, didn't even have lawyers to look over their contracts. Would you represent the tobacco companies if you were working for Covington and Burling in Washington, D.C., which was designed to prevent disclosure, to prevent any regulation, to block any kind of litigation, and to use campaign money to persuade legislators, such as in Harrisburg, Pennsylvania, not to pass any legislation that might hold the tobacco companies more accountable? Would you take that assignment? So you can develop your own hypotheticals. But if you don't do it while you're a law student, you won't have a grounded legal philosophy, and you'll be very vulnerable to be pushed around in that way. Now, there are some law firms that basically allow a matter of conscience to be invoked by young associates. Obviously, if it's a personal thing, it's clearly a civil libertarian thing, they'll bypass it. But if it's a corporate thing, it's much more difficult to get a pass if you want to exercise your right of conscience. Now, at Harvard Law School, when I was there, the law professors were considered the brightest law professors anywhere in the United States. And if you had any doubt, all you had to do is ask them. They practiced something known as the Socratic method, which you are being introduced to. But what they never told us was that the Socratic method was a game only one could play, the professor. And so when it was in the hands of a real expert like Warren Civic on torts or Williston on contracts, it was a masterpiece to behold. But when it was in the hands of someone not as adroit and a little bullying, then it became a very suppressive way. It induced a lot of fear, sometimes deliberately. Any of you who've seen the movie 1L, who've read the book 1L, would know. But what was interesting about that is the narrow-gauged field of intellect by these supposedly very bright law professors. For example, in my class of 550, there were 15 women. And that was only 5 years after Harvard decided to admit women. There were no women at Harvard Law School until 1950. And if you talk to some of these bright professors, including the dean, as to why they limited the entrance of women, apart from prohibiting them until 1950, to 15 out of 550, their answer was that women were more likely, when they graduated and passed the bar, to get married and have babies and then not practice law. And that was unfair to the men. Would you call it the best and the brightest? Huh? Does that surprise you? I wrote a column for the Harvard Law Record in 1956, I think it was, on the fact that 11 states prohibited women from serving on juries. Does that surprise you? Including Maryland? 11. When that article came out and the newspaper was distributed all over campus, there wasn't a single response. Nobody was upset. It just went flat. You see how things change? There were 3 African Americans out of 550. Hispanics, whenever they were in the class, they were largely likely to be children of South American dictators. That's the way it was. Now, I'm looking around this class, pretty diverse, probably not as much as some of you would like. But the question is, other than an upwardly mobile career move now for women and minorities, does it make any difference in terms of justice in the country? Does it make any difference if women and minorities just mimic the career roles of white males? That's what you have to ask yourself. Other than an upward career move, opportunity? Well, let me just run through some of the things that are basically outside the range of what many of you will experience here at law school. There is a joke at Harvard Law School. You know, there are lawyer jokes and there's legal scholarly jokes. And at law school there was a joke that we all chortled because we figured nobody understood it except law professors and law students. And they said at Harvard Law School, in the morning, we contract the law of torts, and in the afternoon, we distort the law of contracts. And everybody sort of laughed. And little did we know that that is exactly what has been happening at an accelerating pace in the last 25 years. The distorting of the law of contracts and the contracting of the law of torts. The latter is called tort reform. Imagine calling something reform that restricts uniquely, not corporate rights to go to court, uniquely the rights of wrongfully injured people to have their full day in court before judge and jury, and restricts it not by judicial intervention, but by legislative intervention. Absentee legislators greased by campaign dollars from the tortfeasors lobby and the insurance lobby to tie the hands of judges and juries, the only people who see, hear, and evaluate the evidence in individual case after individual case in the courtroom. The law of contracts is also being destroyed in any sense of a meeting of the minds. When was the last time you met the mind of the bank that you use? Or have you ever met the mind of Sears? Have you ever met the mind of an auto dealer? Freedom of contract is touted by conservatives in this country as one of the pillars of our democracy. And how much freedom of contract do we have when 99% of all contracts we'll ever sign have already been printed, and all we're told to do is to sign on the dotted line? And if we don't like the Ford dealer contract, and we, in a huff, walk out and say you're going to go to a GM dealer or a Toyota dealer, it's the same contract. The same for Allstate and State Farm. I was just asked to sign a waiver on the use of the videotape of this lecture. Do you see how many times I had to change everything? I was supposed to waive all liability, blanket waiving of all liability. Well, what if some fixture here fell on us or something? And it wasn't defined at all. And I said to the law student, who drafted this? Is this a good example for the law students? And it goes to your student loans. Do you know, I have not met a law student administration yet in America that looked over the Sallie Mae contract, the student loan contract, for the last 25 years, and taken it apart and gone back to Sallie Mae and said, we're here to protect our law students, and in no way are we going to have our law students sign this kind of draconian, trapdoor-filled contract of adhesion. Now, if the administrators of the law school and their contract professors are not going to do that, you think the undergraduate administrators are going to do it? You think the administrators of medical schools and architect schools and business schools are going to do it? Of course not. This is the concept of a controlling process. A controlling process is a restriction on human freedom and opportunity and critical thinking in such a way that is so insidious that it isn't even seen as such, when it should be seen as such. It's hardly invisible. It's, shall we say, professionally excluded from the range of human inquiry. Now, you have a contracts course here. Is it a full year course? Contracts 1? Just a semester. Will somebody here tell me how many hours are devoted to contracts of adhesion in contrast to negotiated contracts between businesses and labor unions and so forth? Anybody tell me? Who's taking the contract course? Yeah, well, I'll pick on Nader's Raiders.
That's more adhesion, not so much negotiation or bargaining, really.
Mostly is adhesion?
I mean, that's what it's geared towards. Are you talking about in reality, or?
No, in the course that you took.
I really didn't like my contracts professor.
Well, the usual answer is 1 or 2 classes, 1 or 2 hours. And the rest is unnegotiated. In fact, just look at the contracts book, right? Well, one answer to that criticism is, well, you know, there's not much intellectual content here compared to negotiated contracts, where there's a huge number of judicial decisions. There's not much intellectual content. Wrong. Think about it. Any kind of suppressive activity, the use of law as an instrument of oppression, has got to have intellectual content to it. It might not be the narrow content, but it's exactly what's necessary to expand your own education. So when you get out of school, you don't just sign on the dotted line. You start asking yourself, well, what if I don't sign on the dotted line? What if I get the auto dealer contract, and I ask the dealer for a chair, so I can read it before I buy the car, and I got my magnifying glass, so I look it over paragraph by paragraph, because, you know, Mommy and Daddy always told me never to sign anything that I didn't read. And you're sitting there, and there are things you don't like. So you cross out a paragraph here, double the warranty there, get rid of the compulsory arbitration clause that strips you from going to court, which no government can do, but judicially approved contracts of adhesion can take away from you. And you got all the, you know, you put your initials in the margin, and then you get it all right, you go back to the salesperson in the dealer room, and you say, here it is, sign on the dotted line. You know, we wrote a book once called Owner's Lemon Owner's Guide, Guide to Lemon Owners, and we had a pro-consumer contract at the end. Nice big type. Wasn't totally unfair to the seller by any means, but it gave the buyer, fairness. And we asked the people who bought the book to go back and tell us what experience is when they went into an auto dealer. And the first letter came back and said, a man goes into an auto dealer and he chooses the car and he slaps down the copy of this contract. And the salesman looks up and says, what's this? He said, well, I want to buy the car and I'm giving you the convenience of a pre-printed contract. You like the sign. And the salesperson goes back to the manager behind the glass door, and the manager calls the police. See how you have a controlling process, and when you erupt it and give it visibility, what happens? There's a survey of law professors years ago, and they said, how many of you read the contracts, the printed contracts, the insurance contracts, and the landlord leases, and so on? And most law professors, they don't read it. And the understanding is, why read it? I mean, it's not exactly a competitive way of doing business, is it? You go to a competitor, you're going to get the same type of law, so why waste time reading it? And that, I think, tells you a lot about the need to revolutionize the law of contracts and to realize that while you can't, at the point of sale, get away with changing things unless you have a congenial vendor, that we can develop the facilities to organize people where these agreements are negotiated beforehand, the way labor management agreements are negotiated beforehand, where they sit around a hotel table or an office, big round table, and they negotiate the warranties. They negotiate the landlord leases. They negotiate the condominium leases. They negotiate the bank deposit cards. They negotiate the insurance policies, and so forth. And that's what we have to consider. An area that was never discussed at law school was federal chartering. Corporations, as you know, are created by government. They're not created by investors. Investors fund them, but they're brought to life by state charters. And Delaware has been the premium easy charter state since 1902, when it took the prize away from New Jersey. And there was a time in Delaware's early 20th century history when a third of their state revenues came from the fees chartering the biggest corporations in the world, like GM, Chrysler, chartered in Delaware, IT&T in Delaware, Citicorp in Delaware, and so on. And that's because it was an easy jurisdiction. It allowed the board of directors and the officers to pretty much do what they want. The shareholders didn't have much power, never mind other stakeholders. And we never discussed that. We never discussed that Teddy Roosevelt and William Howard Taft were proponents of national charters for national corporations. They said it was just ridiculous to have a small state provide the constitutional framework for the relation between a corporation and society. And it was never discussed. It just occurred to me, and we never missed it either. We didn't even know what we were missing in terms of discussing. And one day, some student raised his hand in corporation court. He said, "Professor, why are all these cases that we're studying in the coming from the Chancery Court in Delaware?" And the professor said, "Well, it's quite simple. Why? It has a very intricate jurisprudence. There are a lot of cases, a lot of appealed cases." And it never occurred to the student to say, well, I mean, why are so many corporations chartered in Delaware to begin with? The student could have added, GM could have bought Delaware in a weekend if DuPont was willing to sell it. Never discussed it. It's never discussed in a lot of law schools today. But the compact between the corporate entity and corporate personhood has got to be rewritten. The very idea that we have given an artificial entity all the constitutional rights that we have except the Fifth Amendment and self-incrimination is one of the absurdities of American jurisprudence. Imagine, we're not talking about the employees now, the corporate entity having all the freedom of speech rights, the freedom to lobby, the freedom to engage in political activity like PACs or give money to candidates, the freedom to engage in elections. How can we have equal justice on the law between you, me, on the one hand, and ExxonMobil? It's impossible. These are power-concentrating machines that, with a flip of a computer, can escape jurisdictions around the world and pit one jurisdiction against another. Just think of the tax shelter racket, for example, and the tax haven racket. Just think what they can do under WTO and NAFTA and so on. And we're supposed to have equal justice under the law. And so it's important for you to discuss these things. Why should corporations have personhood? Who gave them personhood? Was it the Congress? No. Was it state legislature? No. It was a rogue decision in 1886 by the Supreme Court, the Santa Clara decision, where the scribe, who was a former railroad attorney, put in the headnotes that the opinion declared that the railroad was a person under the 14th Amendment and equal protection. I mean, can you think of any greater rogue opinion than that, where it was a fabrication? If you read the opinion, they did not decide that. But future Supreme Court decisions used the Santa Clara case as a precedent. When I was at Harvard Law School, we never studied the Santa Clara case. We never raised the issue of corporate personhood. We had in our contracts course all kinds of cases going back to medieval England, but we didn't have one single case involving the sale and purchase of a slave or a slave family. Talk about censorship. I guess the people at West Publishing and the professors didn't want to embarrass the tender consciences of the law students at such an early age. That was a major form of litigation, buying and selling slaves. It went up to the Supreme Court of state after state. Not a single case in the casebook. So you want to ask yourself, what else is being censored out here? What is it that you're not discussing? What is it that you're not being exposed to that is at your fingertips through the internet? If you only knew that you were not what you were not being exposed to. One day I was in constitutional law course and we were discussing a jury verdict against defendants in a rather serious criminal case. And the professor said, well, now, why do you think the jury came out this way? And there were 20 hands went in the air, and he just shot one after another. You know how they love to do that. Ridiculous. Did you get any sleep last night? You know, do you know how to read English? I mean, you can't believe the kind of verbal abuse. It was actually wonderful because it really toughened us up. You're far too soft now. The only way to get a rise out of college students and graduate students today, it's the only thing to get them angry, with few exceptions, and I hope there are a lot of exceptions here in this room, is a gender, racial, or ethnic slur. That drives them crazy. Never mind the reality that the slur represents, like black kids dying from asbestos and lead and not being protected in crumbling tenements in the inner city. You know, it's just the verbal, not the dastardly reality or the deed. Anyway, so the hands, he just knocked them down. Boom, 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 like this. And finally, there's one guy way in the back of this lecture hall. And they were really big lecture halls. And he had 2 strikes against him. One, he was out of his seat assignment. You don't do that. And that was real bad stuff. And 2, he had his foot on the back of another chair. And he raised his hand. And the professor said, "You there!" You know, like he was getting over his, like that. "You there!" And the student said, "Well, professor, maybe it's because the jury was all white." See, the defendant was black, or a Negro, as the word was then. You could have heard a pin drop. All the students turned around to look at this pariah who had dropped the note of reality into the classroom. And it was only 3 years after that the Supreme Court of the United States started going after the discriminatory selection of juries based on race.
So you see, Harvard Law School, touted as the greatest law school in the country, never provided us with foresight in the intellectual discussion. You know why they didn't provide us with foresight? To be kind to them? You know why they didn't provide us with foresight? Because you couldn't footnote foresight. That's supposed to be a joke. That's why. Imagine they were behind the Supreme Court. They should be ahead of the Supreme Court. Intellectual frontiers should be probed by law students and law professors. This is one of the best constitutional law professors the country has ever seen. Well, let's go to the area of corporate crime. Is there a corporate crime course named as such here? Very good. So it isn't white-collar crime. Oh, it's white-collar crime. You mean tellers ripping off banks. Is that it? Huh? Larcenous behavior rather than banks stealing from customers. Until recently, there were no corporate crime courses at the 169 law schools. Recently meaning until about 25 years ago. And then some professors wrote casebooks on corporate crimes. And of course, that is a prerequisite usually for a corporate crime course. So now you have casebooks on corporate crime that are very good, and still not enough cases on corporate crime. Well, we're in the middle of a corporate crime wave, and have been for 15 years. And it's getting worse. Look at Wall Street, Enron, WorldCom, HealthSouth, Adelphia, on and on. And if there's any course that you should have available to you, it's a very rigorous course or seminars elaborating the course, because these defense firms, these corporate defense firms are hiring corporate crime specialists right and left. And they have to have associates. But it is interesting how when there was no demand from these law firms for students who specialized in corporate crime, that the curriculum did not go over that and through that, saying this is a very necessary part of legal phenomena that the students should learn about. And now, of course, it's beginning to adjust, and there are more corporate crimes. Well, but we have an interesting phenomenon here of all of us growing up corporate. And you want to test anybody as to whether they grew up corporate, and just ask them, one, what do they own? Make a list of everything they own. Give them 40 minutes until they're down to paper clips. And then you say, well, you're missing something big. And what's that? Well, you're part owner of the public airways, the public lands, trillions of dollars of government research and development. Your parents are part owners in trillions of dollars of pension money. How come you didn't put that down? That's growing up corporate. Because if we are aware of what we own, wouldn't we want to have some control over what we own instead of let the oil, gas, timber companies control the natural resources that we own and get them free under the 1872 Mining Act for hard rock minerals, gold, silver, $5 an acre. Canadian Gold Company discovered $9 billion worth of gold by its own estimate, billion. Public lands in Nevada invoked the 1872 Mining Act, which is more than a little out of date, went to the Department of Interior and got ownership of that gold for $30,000, $5 an acre. And they can sell it without royalties back to Uncle Sam and leave cyanide contaminated waste behind for the taxpayer to clean up, whether it's a foreign or a domestic corporation. We never even heard of the 1872 Mining Act at law schools. So we grow up corporate in many ways. We grow up corporate in signing on the dotted line and not even knowing that we're giving away our contractual rights and we have any other alternative. We grow up thinking that because the drug companies put full-page ads bragging about their R&D expenditures, that's why they have to charge you high drug prices, that huge portions of therapeutically unique drugs were developed with your tax dollars through the National Institutes of Health or the Pentagon through Walter Reed Hospital research, and given away under CRADA agreements or monopoly marketing agreements to selected drug companies like Taxol, the cancer drug was developed with $31 million of tax money by the National Cancer Institute and given away free to Bristol Myers Squibb, who turned around and charged a woman who wrote us, had ovarian cancer in 2000, $14,000 for 6 treatments. And that was discovered, tested, clinically tested by taxpayer dollars before it was given to Bristol Myers Squibb. See how we grow up corporate? Who sets our standards of human beauty? You think those are community set standards? They're set by the cosmetic and fashion industry. And we imbibe those standards and look at each other from a very young age in accordance with commercialized aesthetic yardsticks. And a lot of it hurts people. Beauty is not supposed to hurt, but when it's defined as something only 1% of the people can achieve in the advertisements and the models, it has its own sanctions. And they're not just social sanctions, they're employment sanctions as well. So in many ways we grow up corporate, which is why you look at those presidential debates and they don't ask about corporate crime. They don't ask about corporate welfare. They don't ask about giveaway of the Commonwealth, the resources of public lands and public airways of the candidates. They're never asked. There's a huge language of avoidance. I hope you remember that word. The language of avoidance is very important. You'll go to professional meetings, legal meetings and other meetings when you're counseled to various NGOs and corporate and trade associations, and you'll see, once you're alert to it, what is not talked about. When I started going after GM and the auto companies, and I wasn't much older than you were because I lost a lot of my friends in traffic crashes, high school, college, law school, and then I began to learn that they could have been saved by long-held safety devices like seat belts and airbags and padded dash panels and stronger door latches and head restraints and even something as simple as a breakaway rear view mirror, which now you have in your car. I got very angry. And when I got angry, I started asking questions that I wouldn't have asked if I wasn't angry. Even if I knew everything I knew, if I wasn't angry, if I didn't have fire in my belly, which psychologists now call emotional intelligence, I would not have had a level of determination and intensity to hitchhike again and again from Connecticut to Washington, D.C. in order to develop contacts to federally regulate that industry. I remember once I was picked up in Delaware by a truck driver, and we started talking. He said, "Where are you going?" I said, "I'm going to Washington, D.C. And he said, "What for?" I said, "To federally regulate the motor vehicle industry for safety." And he looked at me like this. I thought he was going to go over to the side of the road and leave me off for a minute. But you see, the American dream for me was justice. The great work of human beings on earth is what Senator Daniel Webster described as justice. And so let's move to another test of whether you grow up corporate. Ask your friends what they think of the minute you use the following words: crime, welfare, regulation. Crime, welfare, regulation, and violence. And they'll come back with street violence, war, rape, people waiting for their welfare check, government regulation. You say, well, that's certainly within the definition, but quantitatively speaking, far more people die, get sick, and are injured in this country because of corporate crime. Just look, 58,000 people a year die from work-related diseases and trauma, according to OSHA. 65,000 die from air pollution, according to EPA. Over 100,000 die from medical negligence in hospitals, Harvard School of Public Health. 18,000 die because they can't afford health insurance. No one dies in Canada or Belgium or Italy or Sweden or France or Germany because they can't afford health insurance, because they're insured from the day they die. But you see, those are all forms of violence that are traceable to corporate power, negligence, crime, or cutting corners. Therefore, that isn't the definition that we associate when we hear the word violence. 16,000 homicides in this country. Compare that with corporate-induced deaths, for starters. Welfare, there's more taxpayer dollars going to corporate welfare subsidies. I mean, just as we speak, they're bailing out Citibank. They bailed out Wall Street. They're loan guaranteeing new nuclear plants that can't be built without 100% Uncle Sam loan guarantee because the nuclear companies can't get private financing without that kind of guarantee. They're ready to bail out the auto companies, but not a $300 a month welfare mother. So welfare is associated with a single mom welfare, $300, et cetera, but not with the big boys who are on welfare. Regulation, what do you think the fine print is in these contracts of adhesion? They're a form of private corporate regulation of the transactions between you, a very powerless consumer, up against the non-competitive deployment of these contracts of adhesion. So crime, corporate crime steals far more than burglaries. It isn't even close. Far more. Look at the figures in terms of what people are losing from just the non-enforcement of the insurance laws at the state level. A recent estimate had it at $70 billion a year people are losing. That's just one industry. And the coal industry, since 1890, over 500,000 coal miners have given their lives for their companies. Coal miner pneumoconiosis, black lung disease from breathing the dust, and coal mine accident collapses. And that's more Americans who died in that one industry than all Americans who died in World War II. That's just one industry. See how we grow up corporate? Violence, regulation, welfare, etc. We're not defining them also to include the corporate reality of what is happening. Let's move on to government crime. Bush has given us a very intellectually intense menu on that score. This is the most impeachable presidency in American history, easily. And we're not talking about, one-time Watergate obstruction of justice or lying about sex under oath, as Clinton was subjected to in terms of his being impeached in the House. We're talking about 5 systemic, repeated categories of high crimes and misdemeanors. The criminal war invasion of Iraq, the denial of habeas corpus and charges for people who were thrown in jail, a lot of Arab Americans and Muslim Americans by Ashcroft and his successor Gonzales. The third is systemic torture. The fourth, condoned right at the top, now we know that for a fact, right out of Bush and Clinton. The fourth is snooping and spying on Americans without judicial warrant. That's a first-class felony with a maximum jail term of 5 years. And the fifth are the signing statements, over 100, more than any other dozens of prior presidents, where Bush signs a bill into law and says, I'll decide whether to enforce or obey it or not. The American Bar Association, to its credit, in 2005, 2006, you can't get more conservative lawyers, right? They sent Bush 3 reports charging him with serious violations of the Constitution. Serious, repeated violations of the Constitution. They didn't use the word high crimes and misdemeanor, and they didn't use the word impeachment, but that's what the import of their findings clearly indicate. They left that up to Congress and the courts to adjudicate. Now, here we have a very interesting phenomenon where the Democrats took impeachment off the table when they became in control of Congress in January 2007. Pelosi and Reid actually had a statement to the press. Impeachment off the table. Now, does that violate their oath under the Constitution? I think it does, because privately, they have said 100 times they think Bush has committed huge numbers of high crimes and misdemeanors. And they are basically detonating their oath under the Constitution to invoke the impeachment provision and start the proceedings in the House of Representatives. What they are in effect doing is saying that there can be massive systemic daily crimes in the U.S. executive office, in the executive branch of the U.S. government, but there are no criminals. Crimes without criminals. Wouldn't that be a nice third-year paper? Crimes without criminals. And the condoning of these crimes and the prospect that on January 21st or 20th, Bush and Cheney will sail out of Washington on their way back to Texas without any sheriffs pursuing them. without any attorney, district attorney, state or federal, impaneling a grand jury, is to set the stage for Barack Obama, if he inherits the war crime activities of George W. Bush, he will be a war criminal by February 1, unless he engages in immediate executive orders and directives to reverse course in each one of these 5 categories. And in a 97-page report by the ACLU that just came out, they basically said to Obama, here's what you have to do to restore civil liberties and the rule of law in America. And not far from here, anybody here ever hear of the Meckle-John Civil Liberties Institute? Anybody? Nobody? Once again. Now, Anne Fagan Ginger. Anybody hear of her? Okay, she got out of law school in 1947. She's got a lot of experience. She puts out these reports with law student help. This one just came out called Undoing the Bush-Cheney Legacy, a toolkit for Congress and activists. And if you want to get it, the website, it's right in Berkeley. The website is MCLI, M as in Mary, C as in cat, li.org. And this lays out, statute by statute, what has to be done. Only compendium of its kind in the country. And I never heard of it until last night. So some of the most important work is done by some of the tiniest groups who can barely afford to print it. And this is what should be in the hands of the transition team for the Justice Department and a new administration. But don't bet on it. Crimes without criminals. We're dealing here with your responsibility as citizens now and as budding lawyers. You're already members of the legal profession the minute you become a 1L. You become a lawyer when you pass the bar. In fact, when I was at 1L at Harvard, the dean, first words to us was, welcome to the legal profession. You are now a member of the legal profession. We felt pretty good. We hadn't even cracked the book. Member of the legal profession. He then told us there are no glee clubs at Harvard Law School. We know what that meant. And you should always ask yourself, what's the role of collaborative law students? Have they taken a stand on corporate crime? Have they taken a collective stand on impeachment? Have they taken a stand on the subversion of our local, state, and national sovereignty and jurisdictions by WTO and NAFTA-type trade agreements that bypass our courts and regulatory agencies? And what happens if anybody wanted to challenge it in the Supreme Court? And what about the antiquated law of rule of no standing to sue, which is another controlling process to get everybody but the Attorney General of the United States from having access to court to challenge government criminality or illegality? Ask yourself that. Substitute small talk with big talk. The test of a law school's intellectual intensity is the small talk between classes, and among other tests, and test that. My sister and a law professor from Italy just come out with a book called Plunder, When the Rule of Law is Illegal. Can you give an example when the rule of law is illegal? If you can't, it's another example of empirical starvation. There are thousands of examples of when the rule of law is illegal. And the most obvious one is when it is applied in unlawful, arbitrary, and capricious ways, or when it is legislated by a disguised form of bribery in terms of campaign contributions that buy key legislators. And also, it's illegal when, for example, in its imperialistic application by the West against third world countries, there was a concept known as terra nullius. Terra nullius meant empty lands that were not empty, but they were decreed to be empty in order to be seized by the colonial powers. This is the book that will show you that the law in a society of concentrated power and wealth in the hands of the few is vastly used as an instrument of oppression. Every dictatorship claims they're doing it under the rule of law. Stalin did, Hitler did, Mao did, Stroessner did, Franco did, you name it. They all say they're doing it legally. You read the constitutions, you read the statutes. Law students have got to get into this deep area of how law itself is illegal. It could be a statute that's illegal under the Constitution, unconstitutional statute. That's the most traditional definition. But there are many other nuances and permutations that this book will illuminate. You've got about 15,000 days or 2,000 weeks before you turn 65. Did last week go quickly? You haven't seen anything yet. Ask your parents and grandparents. Ask your professors. You don't want to waste your 20s and your early 30s, which are the most creative years of your life, in terms of what kind of law you want to practice, what kind of lawyer you want to be, what kind of attorney you want to be, the two concentric circles, how you're going to elevate the estimate of your own significance, whether you're going to allow your talents to be trivialized because they're paid well for, whether you're going to do important work or lucrative trivial work. I once visited a friend of mine 2 years out of law school, and in New York, he's working for a big firm on a private antitrust case. And I said, "What are you working on?" And he said, the 22nd count of this private antitrust case involving airlines. Oh, that's interesting. A year later, I visited him. I said, "What are you working on?" He says, "The 23rd count of this private antitrust battle," which is basically a battle for turf. Not all that important. You don't want to be subdued in terms of your creativity, your idealism, and your determination to advance justice in our country. By the standard of your health, your education, the country you live in, and the profession you're about to enter, you are in the top 1% of people your age in the world in your capacity to make a difference for the people of this world, 3 billion of whom are trying to make it on $2 or $1 a day, with all that implies. So don't trivialize your talent for higher pay. You may have to do it for a few years, stiff upper lip, pay off your debts, and then do the kind of law where you can bring your conscience to work. This book, which is available out there, is a book I wrote not just for law students. It's called The Good Fight, Declare Your Independence and Close the Democracy Gap. But it will show you, I think, what you need to demand of yourself and your teachers and your administrators in your 3 years, 2 years, or 1 year here. It will go through what happens when we grow up corporate, and what happens in our environmental law, our tort law, our civil and criminal wrongs, consumer wonderland, chapters called Corporate Crime and Violence, Globalization, Foreign Policy Follies, the priorities of institutional insanity. That's a very important concept to develop. The psychologists have developed the institutional mental health problems. I don't like the word insanity, of individuals. But institutions behave in ways that can be described as insane. When half of our entire national operating budget is a military budget, and we no longer have the Soviet Union or any major enemy, although we're desperately looking for one, that's an insane budget. When General Motors fights being toilet trained for 70 years and fills your lungs with noxious and toxic fumes, when their own engineers know how to do better and much better, that's institutional insanity. When HMOs demand pregnant women go into a hospital, deliver a child, and get out in 24 hours, what we call attention deficit disorder of these HMOs, That's institutional insanity. When a drug company sells you a drug for $20,000 for a few treatments, when your tax dollars discovered and developed it, that's institutional insanity. Gandhi, who was probably the soundbite genius of the 20th century, although he never knew it, because his life ended before television, had 7 deadly social sins. And here they are. That's what he called them, 7 deadly social sins. 1, politics without principle. 2, wealth without work. Wealth without work. 3, commerce without morality. 4, pleasure without conscience. 5, education without character. 6, science without humanity. 7, worship without sacrifice. I added 2 more. Belief without thought. And respect without self-respect. When we talk about the law as being an instrument of justice, we must go beyond widespread receiving rights, reception of rights. Rights without remedies are not worth much. And remedies without facilities are not worth much. So it's up to you not just to recognize rights and make them more available, to recognize remedies, like injunctive remedies, and make them, and damages, and make them more available, but to help build facilities that make it very easy for people to band together into powerful citizen groups as consumers, workers, trade unions, small taxpayers, communities, to shift power from the few to the many. We are a very underdeveloped democracy, and it doesn't help by comparing us favorably with Bangladesh. That's the conceit of our society. By our standards, we are grossly underdeveloped democratically and grossly overdeveloped in terms of corporate power over government, elections, our economy, the workplace, consumers, taxpayers, and the corporatization of almost anything that moves, including universities and colleges. And so I leave you with this suggestion. It is up to our generation to provide professional opportunities for you in public interest law. And our generation produced legal services for the poor, expanded to some degree, nowhere near enough, legal aid and public defenders. But that's nowhere near enough for the numbers of law students coming out of law school. To try to remedy that, I organized my law school class in 1958 to start an Appleseed Foundation, which has started 16 centers for law and justice in 16 different states to deal with systemic justice, not legal charity. Charity ministers to needs at the moment. Justice goes to the sources of why their needs are there. Charity feeds hungry people. Justice asks, what are the causes why there is so many hungry people in the richest country in the world? And that's just one law school class. It all starts 30 years out of law school when the alumni start saying, is this all there was to our career? And they start thinking of something bigger. Imagine hundreds and hundreds of law school classes all over the country doing a fraction of what Appleseed has done. And you'll see how many jobs there are for you, the kind where you can take your conscience to work. I also organized with my classmates Princeton Project 55 out of Princeton. Got tired of going back to reunions where all they wanted to do was give us drinks and ask us to write checks for the alumni fund. And this little group now has its own building, and it provides fellowships and scholarships in NGOs all over the country for over 120 Princeton students every year. And some of these students have graduated and made some money, and 2 of them contributed $3 million to buy a nice house right off campus, which is the headquarters for Princeton Project 55. And we did it with a fraction of our class who got together and started the Center for Civic Leadership. And you can look it up. Now imagine if undergraduate classes, 30 years out, 25 years out, did this. In other words, there are all kinds of opportunities to build these kinds of access to justice institutions. That's just one, the alumni. But there are many others, and you should have a course in every law school, a seminar, never mind a full-blown course, on how you can build new institutions of justice. There are only 3 little public interest groups dealing with genetic engineering. There are no public interest groups, citizen groups dealing with nanotechnology, 2 of the more pretentious technologies in world history. That's what I'm talking about being underdeveloped. Suppose you wanted to deal with the law and nanotechnology. Where would you go to work? That's the responsibility of our generation. Your responsibility is to elevate mightily the estimate of your significance, to build the institutions that will advance justice for centuries to come. As Jean Monnet, the founder, one of the founders of the European Common Market, once said, decades ago, after World War II, without people, nothing is possible. Without institutions, nothing is lasting. Thank you very much. Thank you. You have some questions now? Comments? Yes.
Can I ask you a personal opinion about this question? With respect to the subject you've just been talking about, do you think that Obama is going to be any better than Bush?
Yes. He has a very easy act to follow. But the question is, how much better will he be? And will he be more than repealing 1/10 of the damage that Bush has done with his executive orders and his misuse of the Patriot Act and FISA and all that? You know, Obama voted to reauthorize FISA. He voted for revised FISA. He voted for reauthorizing the Patriot Act, et cetera, et cetera. So, you know, obviously, if someone said, would a Democrat have invaded Iraq? My answer is a crazy pit bull wouldn't have invaded Iraq. So, yeah, the question is, where do we end? How far good? I mean, he's put in a lot of Clintonites. That's not a good sign. Not a good sign at all. It's up to us, you know, get the best out of these people. Yes?
You talk about the definition of or corporations running the country, and Roosevelt defined that as fascism.
Yes, he did.
Why aren't we calling the people that are doing this fascist? I mean, you know, yes. Liberal has been sort of criminalized.
Well, I've said that all over the country. I didn't say it today, but that in 1938, Roosevelt sent a message to Congress asking for something called the Temporary National Economic Commission to investigate concentration and abuse of corporate power. And he got it. And the hearings are wonderful documentation, TNEC hearings. And in his message, he said, when government is controlled by private economic power, that's fascism. Those are his words. That's fascism. And now we have far more control over government. Do you know the Secretary of the Treasury, in a page 1 article in the Washington Post the other day, a story on him and the whole bailout, stated that he knew he didn't have the authorities. He didn't have the authorities to do what he did. And there was no outrage. No member of Congress denounced him. We're dealing here with meta law. We're dealing here with executive branch agencies that increasingly are doing whatever they want to do. You know, when we were working on the bailout of Chrysler in 1979, there were hearings, there was debate in the Senate, in the House, and there were stock warrants to the Treasury for a small $1.25 billion loan guarantee to Chrysler. And when Chrysler turned around, the stock warrants were sold for $400 million in profit by the U.S. Treasury. They are now bailing out industries in the hundreds of billions of dollars without even congressional hearings, and with very dubious authorization, as admitted by the Secretary of Treasury. So that's fascism. You know, he was formerly CEO of Goldman Sachs, quit in '06, $600 million sold out, and he's Secretary of Treasury and is bailing out his buddies. And in a very discriminatory way, I might add. He literally asked Congress for a $700 billion bailout in a 3.5-page bill, basically saying, tell me I can do whatever I want. Yes, someone else? Yes?
I really like everything that you've said, and hopefully I understand, but I was wondering, like, what is, like, this justice that you're talking about, and, like, who defines it, and, like, where does it come from, how do you implement it, et cetera?
Well, that's a good question, and that's what law schools should be all about. That Edmund Kahn, the professor of jurisprudence at NYU Law School many years ago, said, you can't have a sense of justice without having a sense of injustice. So I can make it pretty easy, and you can make it easy. You can give certain examples where it's clearly, right? I mean, beating up kids, right? Is that
that's
okay?
Just right.
Not recalling cars with known defects by the auto companies, which have led to deaths and injuries. I mean, there are certain clear-cut issues. You get into tax law, it gets very complex. Some of it is outrageously special interests, like Bahamian tax shelters, yet receiving the services that they have in America. But there are things you can parse, and they become very complex, and that's what lawyers and law students are supposed to be good at. But everything you decide is got to be decided first, is it authorized, right? Is it constitutional? You have regulations, statutes, constitution, so you run through that screen, and then when you agree that it is legal, then the question is it legal by general standards of justice? Or is it basically a power play that got through? So there is no one standard, but obviously, if you're not looking for it, you won't find it. You see, if you've got curriculums that don't look for it, if you've got a judge saying, I never want to see this more justice described. And then you can read Rawls on jurisprudence. You know, you can read, I mean, people have grappled with that for centuries, obviously. But there is a huge consensus in most societies about fairness. And that comes pretty close to being, they're saying what they think is justice is. But as we become more and more complex, I mean, is it just for you to go into a supermarket and not be able to know that a product you want to buy is imported from a certain country or is not labeled for being genetically engineered? Well, most people say, 90% of the people say they want labeling and they want country of origin. To them, that's justice. To Monsanto, that's not justice. Monsanto wins on no labeling. They don't have a vote. 90% of the people who have a vote want labeling, they lose. So, yes?
Recently you've been saying social responsibility and eco-friendliness as being a marketable idea. I don't think it is.
Yeah.
And you can sell that, hey, we're good for the community. Do you think that that's in a way the consumer taking civic power back, or do you think that's actually sending us back because we're equating social responsibility with something you buy?
No, I mean, the consumers can clearly discriminate in their purchases in order to penalize the sales strategies of corporations that are engaged in selling harmful technology, for example. Corporations that are polluting the air, corporations that are corrupting governments, corporations that use serf labor overseas and so on. No, I've always been a strong believer of that. For example, how many people here have never been in a Walmart? How many people here have never been in McDonald's? Where are you from? Okay. You and me are the only two people.
40 years, and I refuse to go to.
See, I was raised by parents who say, don't patronize big chain stores for a lot of good reasons, and so that's my way. For example, I don't own a car because I live in downtown Washington, and I don't want to spend hours every week trying to find a parking place and stuck in traffic. I use public transportation, starting with ambulation, and so on. So you make your choices. For example, there are a lot of, when you wash your hands, you have antibacterial soaps and liquids. That just increases bacteria because it sets it up for mutation, and it doesn't clean your hands any better. It's a fraud. And yet, we all use it unless we see it labeled. And then if we see it labeled, if you have it here in your restrooms, get rid of it. Get rid of it because it doesn't have a scientific basis. It's a marketing tool. It's just making it worse. So if we don't buy any of this stuff, they're not going to start. There'll be a niche for a company to move in. The sustainable economic sub-economy is taking hold. It's not greenwashing anymore. It's beyond their control. The big companies themselves are beginning to see that they're going to lose money, which is the only language they seem to understand outside of prosecution. Yes?
For someone who might be considering going to law school to become the sort of attorney that you might admire, let's say, what criteria should they use to pick between them? And if they were interested in something new like public service nanotech, how might they direct things?
Well, you screen law schools. For example, law schools they tout certain specialties, like in Vermont Law School, very bucolic campus. They're very strong on environment. There are law schools in Washington, D.C. that are very strong on government contracting. By the way, we're on the cusp of getting most government contracts online, which is a revolutionary breakthrough for scholarship, for taxpayer groups, for small business competitors. Just getting them online, I mean, it's half of what government does, outsourcing contracting now. Then there are different, there's a law school at Queens, New York, Queens College Law School. It's very good on poverty law and access to justice. In fact, it's overwhelmingly focused on that. So that's what you do. You look around. Stanford is a good on intellectual property, for example, if you like that. So that's what you want to do. And then the second criteria is the professors. If you really are caught by an imaginative professor that you want to study with, that's another criteria. The third is the courses that are offered. You know, do they give you a lot of leeway, especially in the third year and so on? And the fourth is the student body. Has it been active? Does it have a chapter in the National Lawyers Guild or something? You know, does it have a lot of environmental and consumer clinics? Does it get students into actual practice? And if you want to take consumer law, University of Wisconsin, Madison, they have a very good consumer clinic run by a good professor who worked at the Federal Trade Commission, and that's what they basically specialize in the second and third years.
Hi.
Yes.
Hi, my name is Emilio Camacho. I'm a 1L here. Thank you for coming. One of the areas that concerns me the most is the censorship, suppression, and almost censorship of third-party candidates. For example, I would have liked to see you at the presidential debates, because I think it's very hard to change a society when you keep getting the same kind of guy over and over again at the highest, posts and ranks of the society. So what could we as law students do to help change that?
That's very good. I didn't want to bring it up. I'm glad you brought it up. We're dealing here with either a shared monopoly by the two parties or a duopoly. And basically, they don't like competition. They would be indicted and convicted if they were in the marketplace. And so they put in a lot of state laws, California being one, huge hurdles to get on the ballot. 165,000 valid signatures in 4 months, and you have to get double the number because they can disqualify, some are illegible. So I could go into detail, but my former campaign manager, who's an attorney, he's finished a book on this called Grand Illusion, the fallacy of voter choice in a two-party tyranny. And it's coming out in about 5 months from the New Press publishers in New York. And she describes what she had to go through in '04. 24 lawsuits by the Democrats in 18 states against us in 12 weeks to push us off the ballot. And they did it in all kinds of extrajudicial manner, harassing us through their people on the ground level, our petitioners, getting totally partisan judges to make outrageous rulings, etc. And they knocked us out of Pennsylvania and Ohio. And so we are facing the equivalent of Jim Crow laws against candidates, like they were against voters, black voters. And without candidate rights, voters don't have adequate choices. And so the meaning of voting is depleted seriously when you have no choice beyond Republican, Democrat, and in over 90% of the House of Representative districts, you have a one-party state, gerrymandering. So they carve it up, either dominant Democrat, dominant Republican. They don't even have two-party choices. It's the incumbent, reelected again and again, for over 90%. So over 90% of the people in this country don't really have any choice. It's not even a contest which involves two viable competitors. It's a coronation. So it's hard to get anybody excited about this, the way they were excited about Jim Crow laws. But we're making progress. We've just won 2 Federal Court of Appeal lawsuits invalidating a provision in Arizona and Ohio laws that excluded petitioners who were not residents of those states from collecting signatures for candidates seeking federal office. So we're beginning to win now in the courts. And those of you who are interested in this, just get in touch with us. Our website is essential.org. Just indicate that you're interested. There are students now beginning to do third-year papers on this. In fact, one of them who did a law review article in Boston College is our chief now advocate for candidate access in the United States. And his name is Oliver Hall. You can look up his law review. He did it as a third-year student. That's how he caught our attention. And now he heads the Center for Competitive Democracy, and he's litigating a number of cases. Yes. Let me ask just someone who didn't have. Anybody here wants to ask? Anybody on this side?
Bailout of the automotive industry.
Well, I would. Guzzling, suppressing innovation, but they were making money and they weren't planning as the foreign companies were. What I would do is, I think we should have an auto industry, domestic auto industry. I would have the government become significant shareholders, preferred shares, stock warrants, give them money under technological improvement conditions, conditions that they can't use the money to shift plants overseas, and they can't use it for dividends, and they can't use it for bonuses. And then remove the entire top management and board of directors, put in people who really know how to build cars people want to buy, and technologically innovative, fuel efficient, pollution, and so on. Because there are a lot of good scientists and engineers in those companies. And then when they turn around, the taxpayer is going to make a huge profit. Imagine buying in at Ford at $1.50 a share, when Ford is traditionally $30, $40, $50, $60 a share. Imagine that company modestly turning around in terms of the payback to the consumer. In the meantime, becoming a government shareholder, they can start looking seriously at shareholder rights, which are null now. Yes. Yes?
Yes, sir.
It's an honor to see you and be here with you. Thank you very much. I was just interested, you mentioned the automobile industry, and I was wondering what your thoughts are now today on the aviation industry, specifically the airline, our air transport system, with a lot of foreign interest now and foreign capital investors looking at the vulnerability of many of the U.S. air carriers. Thank you.
Well, as you know, it's now illegal for a foreign air carrier to have a majority position or to buy a U.S. carrier, and that's about to fall. I think that's going to fall. The whole idea was national security. We want a domestic industry. But again, the top management of all but JetBlue and Southwest couldn't have been worse. U.S. Air, United Airlines, over 20, 30 years ago, Northwest, Delta, just ran it into the ground and jumped ship with hundreds of millions of dollars in executive compensation. Classic example of a conflict of interest between the executives and their own company. And once you put them in a conflict of interest with their bonuses and stock options, they'll run their own company into the ground. This is clearly the old biblical warnings of too much greed and too much power in too few hands. As one prosecutor said, no matter how complex these corporate financial instruments are and all of these wheeling and dealings, it all comes down to lying, cheating, and stealing. And so now the lowest paid CEO in the airline industry for the last 20 years presided over a company that made more profit than the top 5 airlines combined, gave you the best fares, great safety record, and cheerful service by people who want to say yes to you. It's called Southwest Airlines. He's paid $750,000 a year, the lowest paid CEO. So all this stuff about we got to pay these guys a lot of money to get the best talent is just the opposite. The more you pay them, the more they have a conflict of interest against their own company. So I think it's probably going to fall. Although the only thing keeping it from falling would be the national security argument. But they'll still give them 49%. You know, KLM's bought into Northwest. Yes?
Yes, Mr. Nader, how realistic do you think it is that significant health care reform will be achieved under the Obama administration?
Well, that's a question we're addressing right now. If you look at the website, november5.org, we are inviting people. There'll be a survey out to our email list asking them if they want that as a top priority for us, all of us to work on. And living wage is another one. I think the problem is that you're going to have, you already have a single payer bill, H.R. 676, 95 members of the House have signed on. And the only time the leadership starts looking at that is when it hits about 170 or 180 signatures by House members. But what will happen is they'll come in with these Band-Aid schemes like Obama's or Teddy Kennedy, who's really for single payer, but he's a realist, as he said. He's tried for so many years. And they will obstruct a single payer move. That's where I think the main danger is. And Kennedy's ill, and they're going to defer to him. And he's going to have something that lets the private health insurance continue. And the only way you can really have universal health care, and that's shown all Western countries, you've got to get rid of private health insurance companies. They have completely perverse incentives. They make more money by denying claims, excluding claims, all kinds of shenanigans. And it's a huge administrative cost of Aetna and Cigna and all those companies. And billing fraud and abuse, massive, manipulating codes. We're talking a full Medicare system with free choice of doctor and hospital, which most people don't have now, HMOs, and quality and cost controls. You've got to have quality and cost controls. The drug companies will blow the roof off, for example, if you don't. So it's HR 676. Check into november5.org. Any other questions? Yes, that'll be the last one. I don't know what's wrong with the students. What are they doing to you? Yes.
Okay, with respect to the subject of third-party candidates that was brought up, isn't it a fact that one thing that lawyers can do and the general public can do to make a big difference is to get behind the movement to require choice voting in all presidential elections in California and in other states?
Yes. I mean, there's different kind of IRVs, as you know. And that way, no one can win who doesn't get a majority. And it's supposed to take care of the spoiler argument. It's already in San Francisco, you know, choice instant runoff voting. And it hasn't reached the state level. It's important to worry about unintended consequences, though. First of all, will people give 3 choices or 2 choices? You know, they may say, I don't want a second choice. I just want McCain or Obama.
Why is that an obstacle?
Huh?
Why is that an obstacle?
Well, it lowers the likelihood of getting a majority vote. And the whole point of second and third choice triggering is to get a majority win.
But is that an argument against trying to get it instituted officially?
No, it's an argument as to whether it will work. I mean, I'm all for trying it. I'm just saying, what does it leave the third party with at the end of the day? So I think proportional rep and public funding, public campaigns, and candidate access for third party independent are more important. All 3 of those are really important. But it's fine. You can try it and see how it works. It obviously works a little different to national than it would at the local, but this good experience can be got at the local and state level. Okay, now I want you to buy this book. And I know I authored it and I'm touting it, but if I don't do it, who's going to do it? This is for your own education, for having a much more exciting legal education. No Contest is in the library now, and read the introduction, and you can, this should be in your law library. Do you know that all you have to do is ask your law library to get a book, and unless it's something out of Hollywood Confidential, they will get it for you. So if you want this book, they'll get it. If you want this book, they'll get it. These are extraordinary elaborations of your legal horizon as students. This is not just another redundant case book. So I'll see you out there, and if you want me, I'll sign it to you. Thank you very much.